Okay. Well, thank you very much for coming on what looks to be a gorgeous fall afternoon. I cannot believe you actually chose to spend that kind of a day in here, but thank goodness we've got windows. So today, Jim Davies, Grayson Chester, and myself, Mark Reinhardt from Rehberg Law Group, we are going to talk to you about the care, feeding, maintenance of something called a credit shelter trust, or has been pointed out to us, also known as an AB trust or a bypass trust. Let me start by telling you a little story. A man can't go to sleep one night. No, he turns over to his wife and he says, "You know, honey, I'm a little worried. If I die, are you going to remarry?" The wife's a little sleepy. She's like, "Oh, honey, of course I'll remarry." Right? He's thinking, "Oh my gosh, what?" He's like, "Well, are you going to let your new husband in the house? Are you going to have this house?" She's like, "Yeah, it's a nice house, sure. With no reason to move. I like it here." So he says, "Well, what about our bed? Are you going to let the new husband sleep in our bed?" She's like, "We just got the bed. It's a very nice bed, so there's no reason not to have him in the bed." He thinks a little while. He says, "Okay, how about my car? Are you going to let him drive my car?" She says, "Oh, sure. Yeah, he can drive the car. That's fine. It's a new car." He finally thinks, "Okay, please don't let him use my golf clubs. Whatever you do, don't let him use my golf clubs." She says, "Oh, don't worry, honey. He's left-handed." Sorry, that will be cut out of the film, but far too risque. Okay, how many people here are clients of our firm, Rehberg Law Group? You've come to us, great work. So a lot of the things we're going to talk about, you've probably already heard from your attorney. How many people here are married or are currently kind of dealing with a credit shelter trust? Nobody wants to confess they're married. Okay, some of you. And to each other. No, yeah, that doesn't matter. Okay, so the bottom line is we're going to see credit shelter trusts are something that primarily is there, right, for married couples. So we're going to be going through your handy-dandy handout here, and I'll try to tell you where we are. But the bottom line is we're saying planning for spouses. So, you know, what's a credit shelter trust and should I have one? The basic idea is that we can try to achieve certain advantages if we plan carefully. But if we don't plan at all, we're going to lose some of those advantages. We're going to lose some control, and we're going to lose some flexibility, and probably the kids or somebody down the chain is going to get taxed more heavily. All right, so I'm going to turn to the next page, which is planning for surviving spouse. Generally speaking, there are two ways we can plan for a surviving spouse. One way is what I call an I love you honey plan. And an I love you honey plan could be in a number of different documents. Typically, an I love you honey plan here in Washington is going to have some kind of community property agreement associated with it. And the basic idea is that when the first spouse dies, everything transfers over to the surviving spouse. It's pretty simple, straightforward, right? It's what most of us think. I write on the board in my meetings and say, "What do you want to have happen when the first of you dies?" And people generally say, "I want everything to go over to my spouse." This can be done, like I say, through a community property agreement in Washington. Washington is one of the community property states, and the idea is we're kind of creating a piece of paper, a vehicle, so that the survivor can show how all the property ended up with themselves. Many times I'll meet with a surviving spouse, and they've been married for, let's say, 50 plus years. Their spouse died a few years ago, and I say, "Oh, I see you have a house. What did you do when your husband died?" They say, "Well, nothing. I've just been in the house. Our accounts were joint." And I say, "Well, whose name is on the title of the house?" Uh-oh, right? If their deceased spouse's name is on the title, pretty usual, right? Joe and Mary, husband and wife. That means they're not able to sell the house later on because the title company, the bank, they don't know how that house transferred over. So most of us have the misconception. We think community property means everything ends up with the surviving spouse after they die. That's not the case. The community property may eventually get to the survivor, but there are things that have to be done, either through a will. We've got a will, we've got to probate the will, or we have a community property agreement between spouses that says, I love you, when the first of us dies, transfer everything over to the surviving spouse. Or we can even do this through a vehicle called the living trust. So any of those tools can be used to transfer things over to the surviving spouse. Pretty darn easy. And the other type of plan is what I'm going to call an I love you, honey, but plan. I love you, I want to take care of you, I want the money to be available for you, but I don't want it all to just end up completely in the survivor's hands with no strings attached. You say, Mark, why wouldn't you want that? You monster, you. You must not love your wife very much, right? Well, we're going to look at some of the reasons why we may not want that. There may be good reasons to say, let's hold some control over those assets with the first spouse to die. They're half of the community property, and their separate property, if any, and have a few little restrictions or guidelines around it so we can get other protections and advantages. So, let's go back to that I love you, honey plan, right? A lot of people have that because they got a plan put into place, maybe a will 20, 30, 40 years ago when the kids were like 3, right? Maybe they only had 1 and then they had more later. They put a will together because somebody said, oh, right, you got to make sure you know who takes care of the kids if something happens to you. So they put it together and they put it in a drawer somewhere and they basically forgot about it. Many, many, many times, those early in the marriage kind of plans, everything goes to the surviving spouse. So let's take a look at how this would work. Now, this shows my age or my generation. I'm using Ward and June as my examples, right? So we have Ward. He's got about $2.2 million in his side. And then June has about $2.2 million in her side. And if Ward, who smoked a pipe a little too much for his own health, right, his own good, he dies, June survives, then he could easily have put in his plan, everything goes to the surviving spouse. Which brings us to, of course, the result, and that is now the surviving spouse has $4.4 million on their side. So far, so good, right? The royalties from, the show are coming in, June is doing well, but now is where we suddenly start running into a few issues. What happens then is when the second spouse dies, we start asking a few more questions. So when the first spouse dies, we essentially have 2 cards that can be played. Okay, let's pretend this side said, I'm going to use what I'm going to call the married card. This is called a marital deduction, which means there's no tax between spouses. So the first spouse dies, everything goes to the surviving spouse. Now, Ward could have died with $300 million and transferred everything over to June, and there would have been no estate tax at that time. So no tax, married card, right? You use that. This side said, I'm not going to use the married card when the first of us dies. I'm going to use my own get-out-of-tax-free card. They decide, wait a minute, I don't want to use the married card because if I use the married card, I've thrown away my exemption from estate tax. And that's clearly what happens. So what happens, instead of each spouse getting their own exemption from estate tax, we risk throwing the first spouse's exemption away. So instead of having 2.2 and 2.2 million free from Washington estate tax, we only have the surviving spouse's 2.2 million. Anything north of that will get taxed. So we're adding at least a couple $1 million onto the taxable estate if we use the married card. So the bottom line is, right, when we're using a credit shelter trust, what we're trying to do is thoughtfully, carefully use the get out of tax free card for both spouses. So that brings us to, okay, Mark, what is this tax-free card? How much is it? Has that changed? So on the table, it says estate taxes. Estate taxes are a privilege on transferring any assets that you have possession over or income from or you enjoy, you have control of. So that includes things like your IRAs, it includes bank accounts, it includes proceeds from life insurance, it includes your home, it includes assets that are anywhere in the world, and it includes things like your couch, the value of that, and the coins that are hiding under the couch cushion. It includes everything of value after you're gone. So, what are the limits? Remember, anything under the limit is a tax-free card, no tax. Anything over it is taxed. So, Washington State is at 2.193 million. That's a strange number. The reason that's a strange number is that number used to go up with cost of living. But the index that it went up to was the Seattle Bremerton Tacoma Index, and the Department of Labor changed that index to be the Seattle Everett Cost of Living Index. And so the Department of Revenue said, see, we don't have to increase the exemption. There is no Seattle Tacoma Bremerton exemption or index anymore. So right now, it's staying at 2.193 million. Anything north of that gets taxed at a 10 to 20% rate. Now, if you have children or grandchildren, does the Department of Revenue say, oh my gosh, we would be sheer monsters to take that money away from young people who need the money? They don't say that. They say if you die, right, it's going down the chain, you're over that number, file and give us our money, right? And theoretically, you have to do all that within 9 months after someone passed away. The federal level is currently very, very high, which is one of the big changes. It was essentially doubled in late 2017. So it used to be about 5.6 million, and it got doubled. Currently, it is now 11.4 million. And anything above that would get taxed at 40%. And Jim and Grayson are going to talk to you about ways that we can kind of work some of the angles and try to keep as much of that exemption as possible. But beware. Many people think, okay, I don't need to worry about the federal exemption ever, ever, ever. I'm not even close to 11.4 million. And if my spouse and I do it right, we're not close to 22.8 million. I don't need to worry about it. Aha! That 22.8 million, the current exemption, is scheduled under law to sunset. So in 2026, it will go back down to what it was before. It'll still have the cost of living increase. We're guessing that'll mean it'll be somewhere around 6.5 million. So if Congress does nothing, and they're busy on just a few other things right now, if they do nothing, right, that means it's going to go back down. And if that includes everything you own, and property and other things keep going up, maybe it's not so hard to get to that number. But if that's the sunset, we also have the perfect storm. And that is, we don't know what's going to happen in 2020. There is an election, so I'm told, depending on who's running and how they're running. But there's going to be an election. In the 2016 election, presidential candidate Bernie Sanders said, I want that number, the estate tax exemption level on the federal side, to be all the way down to 3.5 million. And anything above that would be taxed at 45+%. You say, Mark, that's Bernie Sanders. I've understood him to be a socialist from the Northeast. He doesn't have any chance of winning. Well, that plaque was actually put into the Democratic National Platform. They ran on that, and remember, they did win the popular vote. So we don't know what's going to happen. At this time, the argument, Bernie Sanders has said he wants anything north of 3.5 to be taxed at 45 to 77%. So I would say some planning to avoid taxes may be a good thing, so one of the spouses is not throwing away their exemption. The next slide is very much about points to remember about estate taxes. Got to be paid within 9 months. It includes everything at fair market value. And, you know, your estate, of course, maybe now is fine, but do a few numbers as you do this. What if you average 4% growth, or 5, or whatever it is? Where is it likely to be down the road? So, that brings us back to, are there other reasons other than taxes that we might want to consider a credit shelter trust? Many times I'll meet with clients and, yeah, maybe we're going to run into a tax situation, maybe not. Are there other reasons we might do it? The problem is, if you give everything to the surviving spouse, not only do we run into that issue about estate taxes, we've thrown away one of the get out of tax-free cards that was available to you as a couple, but we have also now potentially put the surviving spouse at some risk. One risk is, what if your surviving spouse remarries? We do funny things in loneliness and grief. Jim and I do post-nuptial agreements or prenuptial agreements, separate property agreements, and I get calls from clients now and then. They say, Mark, I need to come back in. And I know them. I did a probate for their deceased spouse maybe a year or two ago. I say, well, what's going on? They say, oh, I met someone, I'm remarrying. Okay, are you going to do any kind of prenup? No. Right? So we kiddingly call this the hunk or the bimbo problem, right? So Mandy comes along and sweeps your surviving husband off their feet, or Julio the hunk sweeps wife off her feet, right? But Julio may have his own kids. Bambi may have her own drinking and driving issues, or, right, maybe they have a speed dial to the divorce attorney. If you have left all of your money to the surviving spouse, and they get into that problem, it's all available. Washington State doesn't necessarily respect separate versus community property distinctions when it comes to a divorce. And clearly, if the other spouse is in an accident or something like that, it can cause a problem. They could be wiped out, everything gone. The other thing is, what if you're the one in the car accident? I was coming here to Bellevue yesterday, and I come in from West Seattle. I probably saw about 3 to 4 accidents on the way over here, just in a short period of time. So the survivor is driving down the road, and there's the 4, 5, 10 car pileup. What happens? Oh, well, this person caused it. Well, they have no money. Oh, how about this person? They were second causing. Nah, they don't really have any money either. Your surviving spouse has money. Maybe they were only 3% responsible. Well, okay, everybody tags and gangs up on the surviving spouse. So the bottom line is, what you give the surviving spouse directly is subject to those predators and those creditors. And we've also now seen how when you give everything directly to the surviving spouse, unfortunately, you also are throwing away the get out of tax-free card. If you're not worried about any of those things, obviously giving everything away to the survivor is much, much easier. So, what do we do? Well, this goes to the next slide, which is the I love you, honey, but planning through a credit shelter trust. Ward, instead of leaving everything directly to June, because we know how Eddie Haskell was a little bit, a little dubious, right? He could instead say, the money I'm leaving for my wife is left into a credit shelter trust for her benefit. Essentially, what we're doing with this is we're trying to separate control and benefit and ownership. Normally, if we own something, we get all of those. I have my car, I own it, I control it, I get the benefit of it. But we can separate those strands of ownership. The surviving spouse can continue to be in control of the half we put into that side. They continue to be trustee of that trust. They make decisions. Am I going to sell something? Am I going to put it in the market? Am I going to do other things with it? They get the benefit from it. They can get income from it as it comes out. And they can also get principal based on need if their side goes down where it isn't enough anymore. So they have control and benefit, but they don't have direct ownership. So now, if Julio or Bambi comes along, or there's a lawsuit, we have just enough restrictions that the surviving spouse is able to say with truth, this isn't my money. And you can't have it because it's not my money. It is not subject to those predators and creditors. And if we put just enough control around it, which Grayson and Jim are going to talk to you about, then we can also get the doubling of the estate tax benefit. So the I love you, honey, but credit shelter trust idea is a very popular one, especially here in Washington, because there are other elections we can make, and keep your ear tuned for that funny word Q-tip, that will allow us to not only provide money into the Washington state amount, but also make sure we get some federal income tax advantages later on. There's also a slide there to kind of run through a couple of there that say factors in judging whether or not you want to have a credit shelter trust. Some of the benefits would be protection against creditors and creditors. If you have a blended family, obviously it's a good thing to have this type of planning, because when the first spouse dies, that credit shelter trust becomes irrevocable. So if you said, look, when we're both gone, I want this money in my side to go to my kids or my beneficiaries, that's what happens. But if you leave everything to the survivor, they can always change that, right? They can always say, I never see him anymore, or, I want to give it to, the local Moonies who came over, or whatever it is. So with the credit shelter, you can get beneficiary protection, then obviously the estate tax protection as well. There are some negatives, which fortunately I left to my colleagues, so they're the ones that have to give you the bad news. There are some burdens with doing this, right? It's not as easy as just giving everything to the survivor and they go off and do whatever they want. That means one side of the estate is going to be irrevocable, and sometimes people do want to change things. And finally, there may even not just be accounting and tax issues, but there may actually even be some reporting that has to be given down to the beneficiaries down below. So if you are one of our clients and you're trying to figure out, do I have this trust split in my documents? You're going to look in a portion of the document that says first spouse to die, or first trustor deceased. And it's, especially in our documents, it's going to have language saying marital trust and family trust. Or the family trust is what we call the credit shelter trust. And you're going to then look in that section. In our trust, for example, typically that language is in section 2 of Schedule B. So it's about 30 pages into the document, maybe a little bit less. But you're going to find that kind of language there to decide if you have it or not. If you, think, I can't figure it out anyway because it's all written in legalese, remember, we're here, right? We can meet with you, do a checkup, talk about it with you, figure out, is that still the best plan to have?